and honorable members of the House of Representatives meeting as a committee of the whole. Magandang araw po sa inyo lahat. I have here a copy of your resolution of both houses, number 7. And I can see that it is almost the same as the resolution of both houses, number 6 of the Senate, except for a few provisions. In the resolution of both houses, number 6 and of the Senate and your RBH number 7, both treat of the proposed amendments to the economic provisions of the present 1987 Constitution, particularly Articles 12, 14, and 16 of the Constitution, which covers public utilities, education, and advertising only. I was asked, and I am often asked, how sure are we that the Senate and the House will not add any other proposed amendments, particularly political in nature, and limit themselves to these proposed changes in the specified economic provisions of Articles 12, 14, and 16? My answer is that it is limited by the very form of the proposed resolution, which is in the form of a joint resolution of both houses, and it is subjected to the cardinal rule of one subject matter only that must be expressed in the title. So political matters are not covered because they are not in the subject matter stated in the title. So that is the safeguard. So as long as it is only resolution of both houses, number 6 of the Senate and number 7 of the House are the ones proposed and approved, then it will only be on economic provisions, and even then, only on Articles 12, 14, and 16. Now, Mr. Chair, our Constitution, the present Constitution, which was adopted in this hall 37 years ago, I was seated there, seat number 4, as a member of the Constitutional Commission. It has now been in force for 37 years, the longest running Constitution in our history, unamended. And the reason that it has not been amended is partly because of the ambiguous nature of Article 17 on the provision of how to amend or revise the Constitution. The ambiguous nature of the provision proceeds from the fact that originally, when we were adopting the present Constitution, the Committee on Legislative Power adopted a unicameral form of legislature to be called National Assembly. But when it was presented to the plenary voted by a difference of 1 vote to have a bicameral legislative body. I was the vice chair of the Legislative Committee. The chair was Hilario G. Davide Jr. And we both had to revise our draft. The present Article 6 on legislative power is one we had to redraft into a bicameral body. However, we failed to redraft what is now Article 17 on amendment and revision, because that was not our committee. So we did not touch it. So it remained worded as it was originally intended for a unicameral legislative body. That is why it does not distinguish whether the voting should be by separate vote of the chamber or joint. It just says by 3/4 vote of all the members. That is the reason for the ambiguity, and this ambiguity, I believe, is one of the reasons why, until now, there has been no change in our Constitution. Now, about some 5 years ago, I thought of a way of changing the economic provisions, or more particularly, the restrictive portions of the economic provisions of the Constitution. I consulted business leaders, including Washington CISEP, and my idea was to have as an amendment in the strategic places of the economic provisions the words, unless otherwise provided by law. That's my idea, Mr. Chair. And then Speaker Feliciano Belmonte Jr. agreed and adopted my idea and drafted resolution of both houses number 2, which precisely contained such a proposed amendment unless otherwise provided by law. However, that RBH number 2 did not pass. Now, the purpose and effect of such an amendment, Mr. Chair, is simply to make the provision that is to which it is attached, the unless otherwise provided by law, changeable by legislation. It does not do any other thing. It makes it changeable by legislation. This is, to me, the best solution to the economic provisions restriction, because economic provisions should be flexible and they should not be cast in stone. And 37 years is casting in stone. The economic provisions must be responsive to changes in economic conditions. Therefore, I believe that we should change the provisions to make them flexible by legislation, by simply adding as an amendment the words, unless otherwise provided by law. It has to be done in the precise places. Otherwise, you may be confronted with changing the bedrock principles. Don't change the bedrock principles. Change only the percentages of foreign investments allowed, as well as the percentages of management allowed. So do not change when it says that the natural resources belongs to the state. Don't change that. Change only when it says it has to be by a corporation, 60% Filipinos. Public utilities in this case. You change that unless otherwise provided by law, so that a law then can be passed, an ordinary law can be passed, changing the 60-40 limitation. In Spain, for instance, their limitation is not 60-40. It is 51-49. That is still nationalistic. It's still controlled by the nationals, but not 60-40. And many foreign investors are happy with that, 51-49. You cannot do that now. You cannot. But if you have, unless otherwise provided by law, then a law can be passed, converting it from 60-40 to 51-49. That is the effect of this proposed amendment, Mr. Chair. Makes the provision changeable by legislation. The RBH number 6, however, did not follow my formula, the Senate. I told them you should follow my formula. Why? They changed the word basic. They introduced the word basic. That's not in the Constitution. Don't add any word that's not in the Constitution. Just put unless otherwise provided by law. Let Congress define whether basic education should be allowed entry of foreigners or not. That should be by legislation. After such amendments are adopted, Mr. Chair, then Congress can adopt a master foreign investment law that will cover the framework for allowing foreign investments in our country, including, if necessary, safeguards such as reciprocity, for instance, and other safeguards. That's up to Congress. That should be up to legislation, not fixed in the Constitution. That is the philosophy behind this proposed amendment, Mr. Chair. Now, on the procedure, the problem we have is a procedure. Article 17 of the Constitution provides for 3 ways of changing the Constitution. First is by Congress, by a vote of 3/4 of all its members. Second is by a constitutional convention. Third is by a people's initiative, which, as you know, requires signature of 12% of all the voters, represented by 3% in each congressional district. In the case of people's initiative, only amendments are allowed, not revisions. And this can be done only once every 5 years. Okay, those are the limitations. But in the case of Congress acting or exercising constituent powers, there's no limit. It can be amendment and it can be revision. Constitutional Convention, the same. You cannot control what the Constitutional Convention will do. Now, the problem with the first method, which is by Congress, by a 3/4 vote of all its members, is whether it should be meeting separately or jointly, and if meeting jointly, whether voting separately or jointly. As it is being shaped now, it would seem to me that it is going to be voting separately and meeting separately. Because Senate is considering Senate resolution of joint RBH number 6 separately from you. You are considering RBH number 7, mirror image, separately from the Senate. And if you should approve it, 3/4 here, and Senate approves RBH 6, 3/4, that's voting separately. But the substance is the same. So it is approved. You can reconcile minor differences by a bicameral committee, and then come out with the same version, and then approve it again. This is the unified version. You can call it resolution of both houses, number 8 or number 6/7, with common version. It should be the same because it's resolution of both houses. It should not be different. But since you have different resolutions, that has to be reconciled in a bicam. But as long as you have 3/4 vote in the Senate and 3/4 vote here, there's no question. It can be considered as a proposed amendment and submitted to the COMELEC for a plebiscite. And that will fulfill the requirement of the first 3/4 vote of all its members. And if there's any question, then let someone bring it to the Supreme Court for a definitive interpretation of whether or not following what is called the standard legislative procedure is a correct method